do an introduction here. As you guys know, this is 𝗪𝗿𝗁, also known as Pennsylvania Pardon Service. We do podcasts now and then to bring in local business leaders and lawyers and anybody to sort of talk about how their business or their clients are affected by criminal records. And these are really informal chat sessions. And today we have Eric Stark from Stark Law and Alexis Conrad, an attorney with Stark Law. And we're just going to bandy about the interaction of employment law with people that have criminal records. I've already learned a lot of good things this morning, and we just started talking. Eric, why don't you tell us a little bit about your practice and how long you've been in Lancaster and the areas of law that you represent people on?
Sure. So I've been practicing in and around central Pennsylvania for just over 20 years. I have spent the first 14 or so of those years on the defense side of workers' comp and employment matters. So in other words, the insurance defense side of those. About 6.5 years ago, I joined a large firm where we represented employees and then opened my own office. It'll be 5 years in December, where we nearly exclusively represent employees in workers' compensation cases where they were injured at work, or employment matters where there has been some sort of illegal issue or alleged illegal issue in relation to their employment, whether in the hiring process, which probably will be the focus of our conversation today, or during employment, or even at the termination stage.
Right. And that's great, too, because my wife's a paralegal with a big insurance defense firm who occasionally defends companies like Walmart and the airlines and 𝗪𝗏𝗁 Secret and all that stuff. And so there's many, many, many law firms that love to do the defense work and jump in on the company side of things. But it's the plaintiff side of things where my people are having trouble getting employment or getting denied employment. And in fact, we were talking shortly about something we'll get back into, which is it's just famous in the criminal situation where somebody interviews for a job, they admit what's on their record, hopefully, always have to be honest, but then they never get the call back. And so that's why we're going to end up talking a little bit about the Criminal History Record Information Act, which Alexis was schooling me, requires an employer, if they used a background check as part of an interview process, that there is a requirement that the employee, the applicant, receive a written confirmation of why they were denied and a copy of their record, just like people are used to with their credit reports and their credit denials. So talk a little bit about the Criminal History Record Information Act and give us an overview of it. Either one of you, whatever.
I'll defer to Alexis with that. Alexis Conrad has been with us for nearly 3 years. She's been licensed for a little over a year at this point. And as workers' compensation was sort of my bread and butter in my career and kind of remains that way, Alexis has taken an interest in the employment things. And so I'll let her kind of speak and inform us on that.
So the Criminal History Record Information Act governs how criminal history record information is collected, maintained, and used across both public and private sectors in Pennsylvania. So what we obviously focus on is how that affects your employment rights and how they're allowed to use that when determining your fitness for employment.
Are there any rules of thumb or guidelines about that? For instance, many convictions are theft charges. Let's say they're 7 or 10 years old. Let's say you're applying for any kind of position anywhere. Is a theft charge always relevant to virtually any area of employment, or is there a point at which it becomes old enough or somehow unaffiliated with theft or dishonesty that you could become eligible?
Yes, so first, no summary offenses can be considered. So it's only, we're talking the misdemeanors and felonies. So for example, a theft conviction might be relevant for a position involving money handling, but not unrelated work. Say you're in a warehouse carrying pallets on a forklift.
Right.
You know, that's not really going to be used as consideration, what we would think.
So I see that, but then again, would an employer say, well, if they're moving pallets, or even if they're picking for Amazon Prime or something, a theft charge is always relevant because stuff can go in their pocket?
I think what you were talking about, you know, how long has it been since and is he going to steal or she going to steal a 1,000-pound pallet on a forklift? But in Amazon, where you're dealing with small packages, they might have a stronger argument that it is relevant.
But then again, the question is relevant for how long? Lifetime exclusion, or I guess what I'm saying is, does the length of time that goes by ever have any bearing on an argument that it's become irrelevant and shouldn't be considered for the purpose of hiring? Or how would that even come up? Because
to the best of my knowledge, I don't think that there's a time limit.
There's no bright line test, right? So, but I think Mark, you make a good point that the further remote an offense is to the hiring process, the less likely an employer is able to successfully rely on that conviction to deny employment. So while there may not be this strict 5 or 10 year mark, I think anything north of 5 years gives the employee a better argument to say, you can't deny my employment based on a conviction for, retail theft 7 years ago. And I've had a clean criminal record since then, I think, which is another factor.
What we talked about earlier, just briefly, is there's a lot of passive denials of employment. So I talk to people literally every day, all week, who say, I have a 7-year-old something that's on my record, and I put out applications all the time, and I don't get the call back. And I want you to talk about that Walmart case a little bit, if you would, and how to educate the applicants that, first of all, you need to be honest about your record, and you need to know what's on your record, which is where I can come in to tell you, here's your record, this is how you should interview with it. Interview honestly, and then if you think you're being denied because you're just not getting a call back, that's when we need to discuss how to follow up and maybe bring in Stark Law or some kind of process, or have the client advised to go back, or maybe we could come up with a template that the client could either send a letter or an email or call HR and say, pursuant to 𝘀𝗂, I did not receive a call back. I'm requesting a copy of what information was used in evaluating my application in writing, please. Or something like that. I'm just spitballing.
Mm-hmm.
So this case was a little unique because the individual had been staffed there. And when the staffing contract expired, they applied for permanent employment with the company. The company uses a third party out in California who rejected it based on a criminal history. The individual said, well, I can clearly perform my job. I have in the past. I worked there for how many years? And why am I being denied now? And they flat out told him, we are not accepting you based on your criminal history. So that,
that's a dream. That's a dream
exactly,
case.
Yes. And so he had the arguments. And, the company said, well, we used the third party. We didn't even know he was being rejected based off of this. So it really did have the evidence and that you can make those arguments for in that case. But it is more difficult when you're just getting a rejection. Are you being rejected based off your education, your past employment? It's harder to pinpoint what exactly they're denying you for that.
So then what would be the follow-up? Like, for instance, what is the nature of the litigation in 𝘀𝗂? Like, if you had that situation, how does it start? Do you send a letter to HR? Do you file? Do you file in common pleas? Do you file in Fed?
So we start by sending a letter directly to the company to see if they want to talk about it, resolve it without, formal legal action. Typically, these would be filed in county court and state level. However, you can get it into federal court if you have jurisdiction, like diversity jurisdiction, like the company's headquarters are in another state and we're alleging damages over $75,000. We prefer cases in federal court just because they tend to move faster and it's a little more structure. But most of these would most likely be filed in state court.
That's really, really interesting. I'm already thinking of a couple more videos I'm going to do to send out to people in the queue about, do you know why you're getting denied?
Sure.
I'm going to set this up as a path, starting with the people that I interview, about what's on your record, how to interview with the conviction that's on your record accurately, how to follow up with either being denied passively, not getting a call back, or with the temp agencies, if you've been working somewhere, I mean, I got 5 of those last month, and I didn't know what to tell them. So now I do. This is great.
From a damages perspective, you can get, your actual damages. In other words, it would be lost wages. You can recover your litigation expenses, and you can get a reasonable attorney's fee. You can't get non-economic or compensatory damages, pain and suffering, punitive, so to speak.
Right.
However, in some cases, I had a scenario in another area of the law, but similar, where the employer realized that they, took a misstep, if you will, and in doing so, when we pointed that out, the company said, okay, we're going to actually rehire the individual, proceed with the employment, and pay him for the lost wages in between. So that's another option and a potential available remedy for clients who have been denied employment. If you bring this to the company's attention at an early enough point, then they can recover those lost wages as part of the resolution.
Let me dig into that a little bit. Because one of the things I hear from my clients are always nervous. First of all, they're ashamed of having a criminal record. I think everybody that's been through the system has PTSD, and they just know they're being denied because of the record. And then when I talk to them, based on what you've said, they always want to know, well, I can't go back in there, because if they denied me, even if they're forced to take me in, they're going to hold it against me, and they're going to wish they hadn't. And what I tell them is, no, these are HR departments. If they did something wrong and they're going to give you the job, they're going to give you the job because they want you in the job. They're not going to judge you. So you just got to get in there.
Yeah.
So when you talk about damages, let's say I apply for a job, I don't get it. It's this passive denial kind of thing. I send them the letter or the contact that we haven't developed yet that says, tell me why, and they write back and tell me, and then that leads to a settlement letter of some sort, and one of the remedies could be being reinstated in the job. What, as well as back pay, what would be the date of the relative back pay or potential hireability be? From the date of the application review?
Yes, I think the date of the application review, and or if it progressed beyond that to an interview. Sometimes there are even conditional employment offers that are extended. So it would be some date, and obviously for the benefit of our client, we would want that to be the earliest date that we could identify. Those would be the dates that we would kind of look at in evaluating what are the individual's actual damages resulting from it.
Yeah. And also something you mentioned that I'm not sure if my clients would understand or not, though, is because part of the award can be the attorney's fees. If somebody comes to you or they're eligible for these kinds of services, what do they pay you?
Good question. So our fee on this type of a matter would be a contingent fee, right? So typically, most of the time, we would charge a 1/3 contingent fee. There are certain scenarios where we would adjust that based on what is involved with the matter, but it's typically a 1/3 contingent fee. And in the event of a resolution, if we say that, to use nice easy numbers that break down, let's say that the client is entitled to $4,500 for lost wages, then there would be an additional $1,500 that we would demand on top of that. In other words, that 1/3 fee not coming out of the damages.
So they would get their $4,500 and you would get your $15 on top.
Correct.
Does that also mean that the client, when they interview with you, they're not putting any money down up front?
Yes, that is also true. That's the way that we operate from our contingent fee cases.
Yes. Awesome. And I'm really, really transparent. But as a potential referring attorney, if I refer a case to you, do you pay a referral fee?
Yes, we do.
Okay.
Yes.
And that's usually something that happens as part of the referral process. I refer to an attorney. The attorney represents the client, gets the client their settlement, and then the attorney pays me a referral fee out of their settlement.
Correct.
So again, the client doesn't pay anything to have all these lawyers sort of shuffle their case around. It isn't always about the attorneys making money, but the attorney doing the work has to get paid or they wouldn't be able to keep their doors open.
Right.
And at the same time, referring attorneys are important because the easiest way to keep your advertising costs down is by good word of mouth referrals, and hopefully of clientele that are pre-vetted in a way. And one of the things I mentioned is the fact that when I file a pardon for a client, the pardon process is currently taking 4 to 5 years or more. And so I actually have a queue with hundreds of clients that are with me for years waiting for this official forgiveness of their criminal record, and I have not had ancillary legal services to market to them. And yet this is like the heartbeat. This is the number 2 legal service that I think my clients would need. This is where people get stuck. They just get stuck. Yep. They're not getting calls back. They're not getting hired when they've been doing the job. They don't know what kind of attorney to talk to or what to do, and then they just feel down. I'm learning so much. This is like better than law school. All right, Alexis, and what is a typical time frame for you to go through, say, for instance, a CREA action versus maybe another kind of employment action?
So for CREA, there's no requirement to file it with a state level or federal level agency. Like for an employment discrimination case, you have to file with the PHRC and the 𝗍𝗄𝗄𝐿 First. They don't let you, I can't just walk to court and file a discrimination claim. I have to go through the 𝗍𝗄𝗄𝐿 and the PHRC first, which you have to give the 𝗍𝗄𝗄𝐿 180 days to investigate the case.
That's half a year.
Yes. So they're understaffed and overworked. So is it taking 180 days? 80% of the time, yes.
Yes.
It is. And so for a CREA case, I send a demand letter to outline our claims. If they don't answer it, we give them 30 days. The next week I can go and file it.
And then when you file it, what are the time frames?
So it depends. So for federal, you're typically, you file it, you serve it. Depending how you serve it, they have to give your answer. And then you're typically getting a pretrial conference date at least maybe a month or so after you have an answer. State court, it's very different. It's much longer timeline. That's why we do prefer to file in federal if we can.
Yeah, interesting. And so a perfect CREA applicant would be somebody who applies for a job, being open and honest about their record, and either doesn't get a response or is denied. We want them to get written materials about why they were denied with a copy of the criminal history that was used and considered in denying them, and no other malfeasance or misbehavior on the job if they were working, or and then is that pretty much a good applicant? Is that a good?
Yes, I think if you're honest on your application, and I think the best case is the one where you're getting a letter from the employer that says we declined you based on your criminal history.
Was there such a letter in that national case that you did involving?
Yes.
So
they were told outright that it was based on their criminal history.
So that's great. That's a perfect storm, because it's a California company that's doing third-party background checks for a huge customer that is following sort of the spirit of the law but not familiar with Pennsylvania's requirements.
Mm-hmm. Yes.
Where can I get a list of those employers?
If you find it, let us know.
Okay, so that's good stuff, and we can circle back to that, but you also mentioned workman's comp. What's that area of practice, and how does that come into play in the employment situation?
Yes, so oftentimes the two areas of law do interact, and so we represent people who have been injured on the job. There are certain circumstances where there was a potential matter that came into our office that we did not feel was viable from an employment standpoint, but in the process of evaluating the matter, Alexis identified that there was a work-related injury. In this case, it was a disfiguring facial scar. So there was that interaction or interplay, I guess, between the employment matter and the workers' comp matter, where we said, listen, we can't take your employment case. However, you're entitled to compensation for the scar on your nose, and that can be thousands or even tens of thousands of dollars that an individual needs to at least be aware of that.
How does the attorney get paid in that kind of case?
Sure. So it's a similar process. So in workers' compensation cases on we call it the claimant side, where you are the plaintiff in an employment matter,
Right.
it is a 20% contingent fee. That is essentially set by the Workers' Compensation Act, as well as there's an approval process that attorneys need to go through the workers' comp judge. The other nice thing, we're always conscious of not only the attorney's fee, but the tax consequences for our employees. So in an employment matter, such as if we were taking on a 𝗫 matter, it's difficult to not classify that recovery as wages. And so therefore there would be tax consideration. Whereas if we can sort of deal with a dual matter,
Right.
we always want to put any settlement money on the workers' comp case. Number one, it's a lower fee for the client. And number two, it's a tax-free settlement.
That's the kind of smart legal stuff
Yeah.
clients are looking for. And
Sure.
the trouble, again, is the fact that a lot of the times they don't know how it works.
Right.
Your firm does not do personal injury?
We do not handle personal injury matters. However, we have I would say, an extensive local network of attorneys that we would refer the person to deal with, whether it's a personal injury, slip and fall, auto accident, medical malpractice, things of that sort. And what we do, which we feel good about, is that it's a referral to a trusted
Right.
advisor, trusted counsel, not just kind of like, hey, why don't you just pick up the phone and dial this number and see what happens.
Right.
We have those connections that we're able to kind of use for our clients' benefit.
And that's a much better referral system than we're all familiar with the big PI firms that just simply take up TV space, ad after ad after ad after ad. They all look the same. They all sound the same.
Yeah.
We've talked about this passive denial where you're applying to places, you're not getting called back, and we sort of covered that earlier. The other thing is you're actually working for an employer and maybe the company has taken over, or maybe they change their practices and procedures and they start running updated background checks, and then at that point you're told that your services aren't needed anymore.
Yes, based on your criminal record, hypothetically, you would not be protected under the Act because it's only in the hiring process.
So 𝗫 only portends to the hiring process, but is there a cause of action there?
For in the hiring process, or if you're
No.
already employed?
If you're already employed,
There wouldn't be a cause of action then. If you're terminated only because of your criminal history or because of a new misdemeanor you've had, anything like that. There's not a lot of case law in the area of promotions, so that's still kind of up for debate.
okay.
Say you're applied for a promotion and then they did not take you based on your criminal history. The law there's not a lot of answers in that area yet.
But the employer would not be able to say in any way you weren't suitable for the job that you've already had for months or years. And so you're talking about a case where the employer either changes their hiring practices or gets picked up by another company. It still seems to me like you wouldn't be able to just do that willy-nilly unless there was a company-wide declaration of the fact that we are now implementing this policy and we will be running background checks and your job could be at risk. It isn't that formal, is it?
So you would think that's the case. So you would need to find another reason. So is it based on your race and because you have this criminal history now, or are they discriminating against you? But since Pennsylvania is at will, you can leave your job at any time. Suppose you're not under a contract, they can terminate you at any time. And under the law as it is, we did try to make the argument for a case where the person was already employed and there's no cause of action there.
However, if I'm a temp agency and I have this guy in a factory or a warehouse or he's working, and then the temp agency is trying to get me hired in there by the company, and that's where we run into this passive denial thing, that is still part of the hiring process that would be eligible for 𝗫 review, right?
Yes.
Cool.
The other remedy, I think, that sometimes employees do not realize that they have in the context of a termination after the fact, so to speak, is unemployment, right? So an employee in the situation that you just discussed with Alexis would still be eligible for unemployment because being terminated for a criminal offense in that manner after you've done the job for a period of time does not and would not rise to the level of willful misconduct,
Right.
which is the unemployment standard. The big caveat, and you already touched on it, the unless is the person was not honest on the application about the criminal history. That's why that is so important. But remoteness of the offense and the person's performance on the job are also factors to consider in the unemployment context.
Right. And again, when the litigation starts, these things happen either in actually I should ask a question. Let's say unemployment. Do you do unemployment as well?
We do, yes.
Okay. Where are unemployment claims filed?
So they are typically filed by the employee either online or by phone. That then results in what we call a service center determination. That service center determination, which is made by the Department of Labor and Industry, is then subject to appeal to an administrative law judge called a referee. Through the referee hearing, which is often held in a conference room similar to what we're in now, you have the referee at the head of the table, you have the claimant or the employee on one side, the employer on the other side, and it's an evidentiary hearing.
Right.
So there's testimony, there's evidence, there's documents.
So the company puts forward their HR person or a foreman or someone that's familiar with
Correct.
the duties and job descriptions and the hiring and the firing. And this is all done at the state level.
Correct.
So my question is, so unemployment law is filed in a state administrative process.
Yes.
I had a weird memory because back in the day, I went to some kind of weird hearing up in Harrisburg in a little conference room with an administrative law judge of some sort, and I'm a county court lawyer, and I'm used to the stenographers just taking down everything on a steno machine.
Yes.
And this administrative law procedure had a woman with a bag on her nose speaking into some kind of Darth Vader machine. And I just sat there. So I guess that's are they still doing that?
Yes. I still see that.
They do look a little more sophisticated now, though.
Yes, they do. So live in-person events, they're still doing that.
Right.
In workers' compensation matters, for instance, probably 95% conservatively of matters are done virtually via Teams.
Right.
So therefore, in those scenarios, the court reporter, even if they are present, they can mute their device and kind of handle the recording in that manner. But many court reporters still use the verbal or oral repeating into the muffled bag or whatever you want to call it.
I'll have to get a picture of one of those things. And also, just as a court procedure, just for regular, ordinary consumption of knowledge, people need to understand, and I think sometimes when my guys plead guilty, they don't really understand. Like, they see the lady up front with the machine, but they don't understand that every word that's said in the courtroom, every word in an administrative law proceeding is recorded to create a record so that there is always a transcript of every court proceeding, which is called the record. And the reason that's important is because depending on the ruling and the results or the sentencing, the record is what you use to file an appeal to the next level, to make the next legal challenges on appeal. And so it's really sort of cool in a way. Lawyers tend to be sort of wonky librarian types that really love the written word. What about time frame? Like, I go on unemployment, or I contact your office and you tell me I should go file my own claim to get it started. How quick is the original review? and or the denial and or your involvement and or the award?
Yes. Okay, good question. So in the unemployment context, as you can probably imagine, the time is somewhat variable. But typically from the time that you file the claim either online or by phone, you'll have a determination within approximately 2 to 4 weeks, give or take. You then have a strict deadline of that. It was extended a little bit through the COVID process. And you'll note on the determination, it will clearly say last date to file a timely appeal. It originally, previously was 15 days. It's been extended to 20 days to allow for some mail and different things like that. However, you have to make sure that you file that appeal timely, and it can be done via email. It's not an overly complicated appeal process, but it is a strict deadline.
So, real briefly, without getting into the weeds, but the basic principles that would be communicated in email or on the website would be that you were employed by an employer,
Yes.
and you were terminated on such and such a date, and the cause for that or your dispute with that?
Yes, that is correct. They will also ask you questions about your wages and your duration of employment, because that relates to an individual's financial eligibility for unemployment benefits, and or which employer should be responsible for those benefits or charged
Right.
for those benefits.
And again, these hearings, when they're held, they're just sort of par for the course for the company.
Yes.
It's like, this isn't personal where your supervisor's mad at you because you filed for wages or something.
Correct.
It's just par for the course. It's just, and so from beginning to possibly average of final settlement, did you give that time frame?
I don't think I did. So I would estimate, so once the appeal is filed to the referee level, it's again 3 to 5 weeks or so until you would have a hearing, and then the decision is typically issued by the referee within a week or less of the date of the hearing. So from beginning of your application until you get a decision, probably on the outer edge is 8 to 10 weeks. Again, there's further appeals that can be had beyond the referee level to something called the Unemployment Compensation Board of Review, or UCBR. But that process is designed to move relatively quickly, because the reason and nature of someone even needing the benefits in the first place is because they're no longer working.
Well, right, and 10 weeks in the eyes of the law is just blitzkrieg.
Right. That is for
That's
sure.
at least at the common pleas level.
Yes.
Same question with regards to not the unemployment, but the workers' comp. Because I don't know if I asked you where those are filed or how quickly those proceed.
Yes. So good question. So there are a couple of important deadlines there. So the employee has to provide notice of a work injury to his employer within 120 days of the injury occurring, or in the case of an occupational disease, within 120 days of learning of the diagnosis and connection to work. So that is, again, a strict deadline. That notice doesn't have to be so formal as in writing, but it does need to be provided to a manager, a supervisor, an HR department. And if you do not provide notice within that 120-day time period, your entire claim could be barred. So
Right.
That's important. From that point forward, there is a 3-year statute of limitations for filing workers' compensation claims. Claims are filed through the Workers' Compensation Bureau, which is a Department of Labor and Industry entity. Those are filed by what's called a claim petition, which is a complaint, if you will, in common pleas court or federal court, to litigate a claim petition from start to finish. If the claim is denied, we tell clients it can be 9 to 12 months, bare minimum, because again, there is a relatively quick evidentiary process.
Right.
but often medical experts are involved. Independent medical exams are scheduled and completed by the insurance company, and those things can and do kind of slow down the process to the end
Right.
outcome.
When you're having the departmental reviews with these hearing officers, do you get the impression that they are usually fair and impartial and upholding their duty under the law?
Yes, I do. So there are a couple of built-in advantages that employees have in both of those, right? So in the unemployment context, remember that the burden of proof is on the employer to deny benefits,
Nice.
which is to say, if an employer terminates an employee, they have to prove willful misconduct on the part of the employee to deny benefits. That's not a performance issue. That's not a job acclimation issue. That is some conduct that the employee engaged in which violates a policy, stealing time, sleeping on the job, things of that nature.
And willful almost makes it sound like there might have been a warning
Correct.
to knock it off.
Yes, correct. And again, a lot of times that determination relates back to the policy that the employer had in place, the employee's awareness of the policy, and the application of that policy to the conduct in question.
Was there anything else for the good of the order?
So I don't know if you're familiar with, medical cards now in Pennsylvania.
Yeah.
A prospective employer can't deny you employment just because you have a medical marijuana card.
Except
In certain situations.
right, but for instance,
CDL.
yeah. So if they want you to drive for the company,
Mhm.
you have to be clean. So CDL, you can still be excluded.
Mm-hmm.
But you're saying like either warehouse jobs or any kind of employment. Here's the other thing that I mentioned repeatedly. So anybody with a medical card, what's the relationship to that and DUI? This is a quiz.
I believe you can get a DUI if they believe you're impaired, correct?
If you have a medical card and you are smoking every day or every
Mhm.
week, every time you're driving a car, you are under the influence of the metabolites that are used to digest the marijuana that can last up to 30 days. And so the important takeaway is, number one, you don't need to talk. If you get stopped for speeding, you don't have to talk to the officer about your medical card or any medical issues at all, and should not. But also, be prepared for the police officer to look at you and your age and manufacture the odor of marijuana and try to go sniffing around to see if he can't develop probable cause to ask you for a blood draw. So always cooperate. Don't give up too much information. You can also invoke your right to remain silent. But this has just created a real situation because you can have your marijuana card. I don't even know if the dispensaries are telling people you shouldn't be driving, or if you are, you can be charged with more crimes.
So can the police officer ask you if you have your medical card?
Oh, the police officers go to school to learn how to ask people innocuous questions to get you to admit stuff, and just saying, hey, yeah, you were just going a little fast back there. Do you have a medical card? And a good, honest American citizen would be like, yeah, I do, because they think it's a get-out-of-free card.
Yes.
And then the officer's like, really? Well, when did you last smoke?
Yeah.
And then it starts.
Okay.
And then you end up, for my clients, like I'm trying to clear their record,
Mm-hmm.
it leads into a new, fresh conviction. Now the Board of Pardons is saying you wanted us to get rid of a 20-year-old marijuana felony, but you have a current marijuana DUI. You're obviously still using, like in general, but the Board of Pardons thinks if a crime is related to a chemical or alcohol or whatever, and you're asking us to forgive that old crime, we don't want to see indications of it in the recent past.
Makes sense.
And that is tough because with a 3 to 5 year pardon review process, there's a lot of driving going on every day and a lot of traffic stops. So anyway, this is really, I think what I'm excited about is the fact that I'm obviously the oldest attorney in the room. I got my law degree in 1987, was a public defender and then a district attorney for 7 years, and then went back to defense work for 25 or 30 years. And frankly, trial lawyers, like, we went to law school for a reason, and we really like helping people. And then you get stuck sort of in your cubby hole, and you get good at what you do, but you also see the court system just grinding people down. Sometimes they make good decisions, sometimes they make bad decisions. But what I really like about helping people remove criminal records is taking these people that were already not doing well before they committed the crime, watching them get loaded down by probation, not being told what's on their record, being told to get employment and pay the bill or you're going back to jail, and just really just whomping on these people who then lose jobs or get denied. And anyway, what I'm sort of giddy about is the fact that these are areas of law that even an old jaded attorney can sort of get excited about reaching out to people to try to help them improve their lives. So there's something new and sort of invigorating and exciting about just finding this new way to help people with a local partnership. Speaking of which, geographically, are either of your practice areas confined? Oh, I only help people with criminal records in Pennsylvania, but I do get clients from virtually every county, all 67 counties. In your practice areas, are you limited by region or county or location?
Well, we're both licensed in Pennsylvania, so anywhere in Pennsylvania. Now that a lot of things are virtual, we can help people who are out in Erie without them ever stepping foot in our office in Lancaster.
Yeah, that's right. And I think the virtual aspect allows us to represent clients that we might not otherwise potentially be able to help, right? So I think that certainly impacts. We also have a physical presence in Lancaster, where we are today, and then in Harrisburg, really Lemoyne, but just across the river from Harrisburg.
Right. And so what about a phone number?
Sure, you can reach us at 717-844-6350. That'll get you to our main office extension, and then we'll connect you from there.
Okay, and website?
Yes, so we are www.starklawllc.com. So we have a contact form on the website that allows the prospective client to provide us with some background information, obviously name, phone number, email address, preferred method of communication, and then a summary of why the person is contacting us.
I think we can wrap it up here. I really want to thank you for participating.
Thank you very much for having us.
You're welcome.
Nice meeting you.
You as well. Let's do it again.
Sounds good.